Sometimes clients and potential clients will ask us about filling out an authorization. On long-term disability claims, your insurance company may send to you what they call a medical authorization so that they can order your medical records. That is fine until you actually read the form. If you read the form, you may find out that the form has fine print in it, and it states that you're releasing information regarding your credit. So the insurance company can look at your credit repeatedly using that authorization. Is there harm in that? Well, yes, because when there are excessive reviews of your credit score will go down. So as a result, you've got to be careful about signing authorizations that give the right to review your credit. There are also maybe a release in that authorization for your bank to give all of your bank records. Do you really want the insurance company to have all of your bank records? How is that relevant regarding your long-term disability claim? That doesn't seem quite fair to give carte blanche to an insurance company to obtain all your financial information, maybe even your tax returns. There also have been authorizations that release information to the Medical Information Bureau. Now, what is that? When I see MIB Inc. right away, I'm thinking Men in Black, the movie. It's not when it's in an authorization. It has to do with this database that insurance companies participate in, and it shares medical information between insurance companies. There may be some reasons you don't want to share medical information between insurance companies. If they team up against you, it hardly seems like it's fair, especially if one makes a mistake and then that erroneous information bleeds over to the other insurance company, creating a mess and putting you in dire financial straits. So you have to be careful with these authorizations. The authorization also may release even your own attorney's information. So information that is supposed to be protected by the attorney-client privilege may be released by that authorization. So you don't want to just sign those authorizations. So what do? The insurance company may have sent you a letter and said, you have to sign this authorization, and if you don't, your claim may be denied. Okay, so that sort of puts you over a barrel. Well, what I tell my clients is don't sign the authorization. Give it to me. And I go through and I strike out the objectionable parts of the authorization. And then I send it back to the client for the client to sign. And the client will then sign it, and then we forward it on to the insurance company with a nice letter that says, this authorization was overly broad and it unnecessarily invades the privacy rights of my client. It also could be subject to abuse. There have been data leaks from long-term disability insurance companies that have caused people all sorts of harm when that ends up in the wrong hands. So there are a number of different reasons why you don't want to sign those authorizations, and I explain that nicely in the letter. And then I also add, but if there is something that you specifically need, please feel free to contact me and we'll discuss that with you and ascertain what we can obtain and provide to you if it really is necessary. And of course, the authorization allows for the release of medical records, and we don't object to that. Go ahead and get the medical records. If the authorization, however, allows for any of their people or even a third-party vendor to talk with your physician, you may want to be careful about that. Because if that third-party vendor is allowed to talk to your physician, that vendor may say, well, I talked to the physician and the physician said that this particular patient can go back to work, that they're fit as a fiddle and ready to work. And that may not be true. Yes, that has happened in cases that I have seen. And so when you have these false assertions being made, I don't think that's fair. So I always strike that information as well, and I also let the insurance company know if you want to talk to my client's physician, well, we can arrange that, but I will likely want to be on that phone call, or we are going to want the phone call to be taped. Those sort of things then safeguard against false information being shared. Every now and then, I've had a long-term disability insurance company say, well, if you're not going to sign the authorization as it is, which is our industry standard that we're following, then we're going to deny your claim. And in response, I say, bring it on. You want to deny my client's claim when the client has all sorts of evidence demonstrating that the client is not able to continue performing their own occupation or an occupation that they're qualified to perform by reason of their education, training, or experience, then fine. We'll let a judge decide that matter, especially given these overly broad and invasive issues. So there you have it. It's a little bit complicated when you're dealing with insurance companies on long-term disability claims. And there are things that you have to do to protect your rights during the claim process. When you have these issues arise, give us a call. This is what we do for a living. We're here to help. Thanks.